Good morning, everybody. Thanks so much for joining us and welcome. And today we're talking about body corporate spending limits. This session is particularly for Queensland. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, a body corporate management company in Queensland. I'm your host for this webinar, and we're very excited to be joined by someone I'm sure many of you know, Frank Higginson from Hynes Legal. We had a webinar with Frank back in July talking about the differences between maintenance and improvements. And in that session, there were lots of questions about spending limits, and a viewer requested we explore the topic separately in detail. And so here we are. While some of our sessions that are state specific are applicable around Australia, we do stress that this session is based on Queensland's body corporate legislation, and it is not applicable in other states. Spending limits are complicated. But why? It's because rules and regulations are scattered throughout the legislation. But Frank reminds us that although it's a challenge to piece these rules together, they do exist for a very good reason. Now, before we begin, I'd like to mention, as always, that the information in this session, including the discussions arising from submitted questions and chat conversations, is not legal advice and should not be relied upon as advice. You should seek independent advice before acting on the information contained in this session. So today we're welcoming back Frank Higginson from Hynes Legal. Frank has practiced almost exclusively in strata law issues for the past 20 years. He and his firm act for bodies corporate, management rights owners and lot owners in their strata issues. He has been involved in working groups about the new Queensland laws since discussions commenced in 2020. So it's great to have you back with us again today, Frank.
Happy to be here, Nikki. Perfect. Righto. So, body corporate spending limits did fall out of the back of the maintenance and improvement one. And it's funny, these things are good for me. I mean, I enjoy doing this, surprisingly enough, but it puts you on the spot to answer a bunch of questions without notice, but also to go back and revisit the legislation and read it. And I think, again, having gone through it and looked online and read some adjudications and read the legislation, search bits and pieces, it just reminds me how complicated it all is, always. So I've got a point here to get legal advice on these things. So don't take, I suppose, in a sense, what I'm saying today is absolute gospel that's applicable to your specific circumstances. There's a whole bunch of things that, as always, the same as I did one on proxies a while ago, there's stuff hidden in different parts of the Act and the modules that refers to things and they're not other things. And you really need to check it every time, as scary as that might be. And is it too complicated? Yes. But is it the law? Yes. So there's just no shortcut. So with that caveat, we might start with what I'm going to talk about today. So spending limits are committee and general meetings. Obviously, it's starting point. Major spending limit, which a lot of people sort of, you'd almost colloquially call it the two quote rule. So I'll talk about how that works. Emergency spending and alternatives for that. And then probably some of the things that people might fall foul of that you're not necessarily aware of and how these things interrelate with other sections. So starting point, background for today, absolutely this is Queensland specific. I don't know anything about spending limits in other state regimes. Occasionally get asked the question of when we're going to have national strata laws, and I think it would be so far down the bottom of the list of governments, it's not funny. So probably never would be my take. So you need to understand what goes on in your own jurisdiction if you're looking at this. But from a Queensland perspective, it's relatively prescriptive. So again, that usual nanny state comment, and the counter argument to that, well, is if we didn't have rules, what goes on? So and Queensland in a sense has evolved from the Building Units and Group Titles Act in 1980 through to the BCCM Act in 1997, and 26 years later, here we are. So there is 40 odd years worth of, actually before that was the Building Units Act of 1973. So there you go, sort of 50 years of specific strata legislation in Queensland. And probably where government's gotten to is it's better to be more detailed than not. Because if any of you are in BUGTA schemes, and this is not BUGTA related, this is BCCM related, you'll understand that sort of it's a bit Thunderdome-ish at times, sort of two men enter and one man leaves type stuff, but the basis on which they leave is never really prescriptive. So from a BCCM perspective, there is a lot of detail. So, but what I'm talking about today is really standard accommodation and small schemes rules. Commercial, if you're in a commercial scheme, you're almost off the reservation. And two-lot schemes also have the ability to do effectively almost whatever they want, in a sense, because everyone's on the committee. So the committee and general meeting are roughly the same. But so if you're in standard accommodation, which is going to be the vast bulk of people that are probably listening to this webinar or watching this at a later date, this is applicable to you. Interesting question. Why are there spending limits? And I thought I'd just cover that. It really, probably the best analogy that I use for bodies corporates all the time is it's really like a company and its shareholders. So what you have in a company, everyone's a shareholder, which is what in a body corporate, everyone's a unit owner. And that company or the body corporate elects a committee or a board to do the day-to-day management of that enterprise over a 12-month period. So the same as you see at corporate level, company boards can make certain decisions, but not others, and they're required general meeting approval. Same thing, the same analogy is really applicable in strata. So what our legislation does is absolutely prescribe relatively strict spending limits for bodies corporates, but with the ability to change those down the line as they choose, to, in a sense, make sure that committees don't go and spend more than what they actually should. Now, I know one of the first questions everyone's going to ask, and there's probably 1,000 of them there, Nikki, is, but what happens when they do? And I'll cover that at the very end. So bear with me, but I'll go through the rules to start with. So really, why are there spending limits? It's because the government has said these are the protections we want unit owners effectively to have that aren't involved in the day-to-day management of their scheme. So that aren't on the committee, that are sitting there probably in blind ignorance potentially about what their rights and responsibilities might be and what their committee's actually doing. So the government has seen fit to say, no, there's going to be a restraint on certain types of spending and certain types of decision making, which applies to restricted issues and all sorts of other things. Now, the other thing is if you want to do some more reading, there is a heap of detail on the Commissioner's Office. Again, very Queensland specific organisation, created specifically to deal with strata issues and provide information about strata issues. So if you want to really sort of learn yourself up in terms of what goes on, just Commissioner's Office Queensland, Google that and read until your heart's content. They don't produce as many webinars as I suppose third-party providers like Nikki and other organisations might, but in terms of written content, it's spectacular. So spend some time on there and look around. And lastly, as I said before, make sure that if you've got something that's important to you, that you actually go and get legal advice on it, because there's carve-outs and exceptions. And one of the things that the adjudicators in the Commissioner's Office have the ability to do is to make orders that are just and equitable in the circumstances. So that effectively allows them, in the right circumstances, to say, well, even though the legislation says that, this is the position. So you can be on the wrong side and the right side of those, in a sense, equitable abilities that adjudicators have in the Commissioner's Office. So there is always, to me, in most body corporate disputes, there might be a legal or a factual issue, but there's also going to be the vibe. If you go back to the castle, it's really hard to describe in a sort of legalistic sense, but you look at some things and go, well, that's just not right. Adjudicators have the ability to sort that stuff out, even if it doesn't necessarily conform with what the legislative requirements are. So that is certainly the case in relation to some of the spending decisions and disputes that have gone on in there over the years. So with those caveats, let's start with the default committee spending limit. So we're at committee meeting here, we're not at general meeting. And that's pretty simple. It's that $200 by the number of lots in the schemes, So including GST, this is one of those things. BCCM Act arrived before GST appeared. And even though, of course, $200 in 1997 buys you a lot less than $200 today, here we are, hasn't changed. Now, the other thing is that, and this is one of the changes that happened in the new modules that we got in, crikey, Nikki, 2020, I think it's before COVID, or just as COVID started. I can't remember now. COVID's just a time warp. One of the issues that used to be the case in principal bodies corporate was that if you've got a principal, say you've got a principal body corporate which has 8 subsidiaries, So you've got, subsidiary 1, 2, 3, 4, 5, 6, 7, 8. In theory, those subsidiaries are only one lot each. So what used to happen at principal body corporate level is effectively a principal body corporate committee was hamstrung by statutory spending limits, because if there's only 8 lots, their spending limit's $1,600. And there's obviously a much bigger pool of people that would be paying in relation to those PBC decisions. So what happened in the new modules is the definitions for principal bodies corporates extended to the number of lots in the subsidiary schemes. So rather than have a spending limit of $1,600 for 8 lots, if each of those subsidiaries had 10 lots in them, suddenly you're 80 times 200, so your spending limit's 16 grand. So that got changed with the modules. Now, the thing that's really not interesting, but this happens, carve out for insurance spending. So if you as a body corporate are worried about getting owners' approval for a spending of insurance or whatever, it's a matter of making sure that the timing for the renewal of that policy is probably directly after your AGM. So insurance policies can come due, of course, any time of the year. So if you've got an AGM in October and the policy's coming due in September, there's a carve out there that allows the committee to put that in place, and then it should be ratified at the AGM. But if you're worried about getting approval for that from owners before you do it, then it's a matter of changing the, extending your policy by 2 months or a month or whatever it might be, so that it falls due after the AGM has been held. So at that stage, you can ratify the insurance or make a decision on it and put it into place. But that's the default position for committee spending. So you want a magic thing to walk away with, it's $200 by the number of lots in the scheme, full stop. Now, bodies corporates, and this is one of the things that the government offers, I suppose, in a sense, is this self-determination element. So sometimes I think in strata, there's an illusion of choice, where if you look at any AGM agenda, first thing is confirmation of the minutes of the last meeting. Second thing is going to be approval of the administrative fund. Third thing is going to be approval of the sinking fund, and so on. Those things look like you've got a choice, but from a statutory perspective, you actually don't. You need to have a budget. You need to raise levies. Body corporate spending's fairly specific in terms of what you've actually got to do. There's no discretionary element of it. So all you might have to do is tweak around the edges a little bit with some of the quotes or whatever, but ultimately you've got to do what you've got to do. Now, when it comes to spending, the government has said to bodies corporates is that's the position. It's $200 by the number of lots in the scheme, but you can change it. So you can change it up or you can change it down. So there is no minimum and there's no maximum. So if you wanted to, you could reduce the committee spending limit to 0. And what that would mean is that every single spending decision needed to be approved at general meeting. Now, of course, that's not realistic. Doesn't make a whole lot of sense and probably be a bit counterproductive, because the cost of the general meetings to approve all that spending would be outweighing possibly what you could be saving in terms of committee making poor decisions, usually. And the same with the maximum. So government has said, well, if you want to take that from $200 to $15,000 per lot to allow the committee to spend it, go for your lives. Completely up to you. It's up to you to decide as owners what restraints or fetters you want to give or impose on your committee. So very simple, ordinary resolution. Now, in terms of some of the easy examples, obviously general increase or decrease, $200 to $400 might be a bunch of big expenditure coming up. Maybe there's been some over-the-top expenditure in years gone by, so maybe they'll be trimmed in bigger buildings. Where we see things, probably last one's obviously quite funny, renovation projects. So when there's a big project coming, it's not too hard, particularly I suppose in today's age, to go with construction costs and labour and all that sort of stuff to be miles above the spending limit. You can give a committee, or a committee can get the ability to spend, $1,000 per lot overall, or limited to a specific project. So if we're redoing the driveways and the pool, then maybe the body corporate could say, okay, the committee can now spend $1,500 per lot across that entire project pool for those specific things. So not generally and not forever, but once that job's done, it reverts back to the $200 per lot per annum. But for this specific gig, you guys can do that. We trust you to do that. And if you've got a committee that knows what they're doing and take control of things, then that means they don't need to go back to owners for approval at general meeting when they're spending money on that particular project. The alternative, and I've absolutely seen this before, is and we were the trigger for this, I suppose, on the we dished it up end. The committee that was going a little bit crazy in terms of what they were spending money on wasn't even against a client we were acting for, which is a strategic tactical strike at times, but it was, these guys are idiots and they're spending way too much money on lawyers. We need to rein them in. So, okay, well, here you go. So this committee can only engage lawyers up to $4,000 at any given point in time without owners approving it in general meeting. Done. Sorted. So now I'll talk about, again, at the end, what happens when that sort of stuff gets breached. But there is the ability for general meeting, ordinary resolution, to create a substantial degree of flexibility for committee spending overall or on specific projects or specific items. So that's something to bear in mind. And it is, again, I suppose, reflective of the flexibility that the BCCM Act can offer. Now, the next thing, which is a concept. So we've got committee spending there, $200 per lot per annum, inclusive of GST, not per lot per annum, $200 per lot, can go up or down, ordinary resolution, where we go. The next thing is the major spending limit. So this is another statutory definition. So the major spending limit, $1,100 by the number of lots in scheme, or $10,000, whichever is the lesser. So again, I suppose you've got any scheme with more than 10 lots is 10 grand. And interesting enough, that 1100 sort of looks at GST, but there you go. So some GST inclusive and some GST exclusive numbers in a sense, but that major spending limit can also be changed by ordinary resolution. Now, the context for the major spending limit being included in the legislation is that if the spending, and of whatever nature, be it committee or general meeting, is under that amount, you don't need two quotes. So this is also sort of the major spending limit is what you'd say is the statutory term. The industry, I suppose, is this is the two quote rule is where we're going. So if the spending's under that amount, you don't need two quotes. So if you're gonna, if you're gonna spend something $5 grand's worth of work, legal work, come to a lawyer to get a quote for a job, you don't need two quotes at law. You can absolutely get them as a matter of best practice or because you feel like it or whatever it might be. And same with any service provider, but you're not obliged to. That's the difference. So if the amount, though, that you're going to spend is above the major spending limit, then you do need two quotes. Now, that is either at committee or general meeting level. So this is where these things can converge. So, you might have, like a figure, go back to that principal body corporate I mentioned before, that has its spending limit. It's going from $1,600 to say now $16,000 at committee level because of the new modules. If that body corporate hasn't changed its major spending limit and that stays capped at 10 grand as per the legislation, what you've got is a committee that can spend 16 grand. But if it is going to spend more than 10, it needs to have two quotes above that $10,000 limit. If it was spending $9,000, it could go with one quote if it felt like it. So this isn't to say that body corporates can't spend more than that. They can, but there's that, I suppose, layer of corporate governance that the government seen fit to put over the top. Whereas if you're going to spend that money, you need two quotes. Now, again, that major spending limit can change. You've got a big building, big project. Maybe you want to change it to 40 grand specifically for this little period of time to allow the committee to go and deal with that roadworks or the pool resurfacing or whatever it might be. If you change this major spending limit up, that means the committee doesn't need two quotes. But to the extent it's still at that statutory level, more than 10 grand, then they do. Now, there's some carve-outs, as always, with strata, as you'd expect. And probably got those in the wrong order. There you go, Nikki, in terms of the points. You don't need two quotes if there's exceptional reasons. Now, what are exceptional reasons? The statutory example that they use in the legislation is where what you're getting is goods of a particular characteristic or only obtainable from one source. Now, of course, that's all that the legislation includes, but there's multiple other reasons that might be applicable. And those depend completely on the circumstances of what it is you've got to talk about. So, for example, one that we've used in the past, we're acting for a body corporate, we'd been involved in assisting in relation to a particular issue for about probably 2.5, 3 years. And then it suddenly, and we're dripping along there. It wasn't a project. We're just sort of charging hourly rates as we went, nothing major, not big expenditure, blah, blah, blah. And then a proceeding was commenced in relation to that by someone, not us, that meant, okay, it's suddenly going to get expensive. So we were definitely going to spend more than 10 grand. The committee decided there, and we didn't get challenged on it, but the view we took at the time was that, we tell our clients, here's this issue. Exceptional reasons may well be is that we've got 2.5, 3 years worth of knowledge about what's gone on and what's happened and strategy and documentation and all the rest of it. Going and getting a second quote from another lawyer isn't really going to be comparing with apples because they need to spend who knows how much time trying to understand it. And the committee was completely confident with where we were taking them and what the position was. So that would have been, I think, good grounds for exceptional reasons. And not that we got challenged, which is fine, but it's sort of those sort of things are a bit left field that might work, but you need to be prepared to justify them if you're going to run that argument. So, if there's only one provider of this particular thing in the country, maybe that's an example. But you'd have to apply it to your own circumstances. And it's certainly easier to get 2 quotes than it is to try to run the gauntlet and preserve the position about why you didn't on challenge. And of course, just because you got 2 quotes doesn't mean you need to go with the cheaper one. Body corporate can choose who it wants to go to and go with. It might choose to go to the more expensive one, but the main thing is that it's got 2 quotes. And of course, down a level, as much as the legislation doesn't actually prescribe this, it would be, you've got to make sure you're comparing apples with apples. So a quote to buy a crate of apples versus a quote to buy a crate of oranges is not 2 quotes about the same thing. So you've got to make sure that the scope of works and all that sort of stuff is relatively tight and consistent to allow people to actually make that comparison. Now, the other thing is that if you're going to put 2 quotes up at general meeting for approval, then you need to put it as a same issue motion so that we engage Frank to do X at a cost of Y, or we engage Nikki to do X at a cost of Z. And people vote yes, no, or abstain, I suppose, if they want to, on those particular choices. Now, of course, same issue motions are at general meeting level. At committee level, we get asked this a bit, there is no such thing as a same issue motion. Committee just makes a decision. So they need to have the 2 quotes in front of them, of course. So if you've got a committee of 4, they've got the 2 quotes. They say we're going with Frank or we're going with Nikki. So that's again in that little vortex that is under the committee spending limit or within the committee spending limit ability and above the major spending limit threshold. So there's probably a flow chart or some sort of picture I could do here, Nikki, but I'm thinking in words rather than pictures at the moment. So that's the 2 quote rule. So again, I suppose if you want to really, the takeaway from that for me is what is the major spending limit? And if the spending's above that, you need 2 quotes, unless there's those exceptional reasons. Now, the next thing that pops up is emergency spending. So we need to do this now. It's urgent. So, and probably, I did chat to my litigators about this one, who do all of our Commissioner's Office applications and the rest of it. I do remember, I might say 10 years ago, I don't know what time it is again, I remember reading some of these decisions where people would make an application to have expenditure approved on an urgent basis, and adjudicators would look at it and say, well, that issue's been going on for 6 months. You've had that long to deal with it. If it was urgent, you should have been in to see us 5.5 months ago and you didn't. Now you can wait normally. Now that my litigators tell me the sort of adjudicators aren't necessarily as brutal on that or look at emergency spending applications in that same way anymore. They do tend to look more at the nature of the issue, whether consequences that'll flow from it not being dealt with sooner rather than later, regardless of how long it's actually been going on for. Now, to me, I think in making an application for emergency expenditure approval, you would definitely need to address why things haven't been done if the issue has been looming for a while. Like, to me, that's a logical thing you'll need to address because it's a legitimate question from an adjudicator. If it wasn't urgent then, why is it urgent now? And hopefully the facts support what that actually might be. And I suppose in a sense, it might also be a little bit of a reflection of the fact that committees are volunteers. They got a whole lot going on. And until people really start screaming, maybe it's not as urgent as otherwise might seem because there's other things going on in everyone's lives, and maybe COVID's changed that. I don't know, but it's not as brutal as it used to be in terms of refusing the things by all reports because it's been going on for a while. That's probably one takeaway. Now, there is on the Commissioner's Office website a practice direction about what you need to set out if you're going to make an application for emergency expenditure, and they're pretty specific in that about saying that it's got to be a current, genuine emergency requiring immediate action, and it's not a shortcut to avoiding the normal approval process that you need to go through. So be that spending limit, 2 quotes, or otherwise. So the practice direction specifically says you're going to need to tell us why, what it's going to cost, to me, address why it hasn't been dealt with to date. If you've only got 1 quote, why you've only got 1 quote. And again, that might be in exceptional circumstances where we've had 1 person working on this issue. If it's a construction issue, we've had 1 person giving the body corporate advice for the last 12 months about all this stuff, and they know where all the bodies are buried and all the issues are, and they've been working with us to try to find a solution, and here's their quote. And it's bloody hard to find tradies or contractors who are available on short notice to deal with this stuff, so that's why this one's exceptional. And to me, that would probably fly. But if you're going to make one of these things, you need to make sure you meet the criteria of the practice direction, or you'll get bounced. Now, the other thing that you can do, and this is back to sort of self-governance and giving people the ability to make their own decisions, is consider a time-abridged general meeting. So general meetings in Queensland still require 21 days notice. Most people are probably doing it electronically now. So, you can send it out on the day 22 and then have it on day 0. So everyone's got it for the clear 21 days, as opposed to when things used to go by post. So we were at that stage going to 30 days notice and all the rest of it. Adjudicators, again, have the ability to abridge time for general meetings. So the example I always use for this one is we are acting for Tennyson Reach, which got flooded in the 2011 floods in Brisbane. All through the building, Mirvac still owned, I think, 1/4 of the units, not all through the building, up to first floor and so on. Mirvac owned 1/4 of the units, obviously wanted to help everyone get sorted. So what we did there, and this application was turned around in under 24 hours from filing to receipt of decision, obviously some fairly intense activity. But what we did there was we got Mirvac agreed to go and do a whole heap of additional work or works required to get this stuff back up and running, the building, immediately at cost. So, but that was miles beyond major spending limits and committee spending limits and general meeting approval limits. And we needed to do a whole heap of other additional work that required approval. So what we got from the Commissioner's Office was a bit of a blend. We got authorisation to go and incur this spending straight up. And we also got authorisation to call a general meeting on 7 days' notice to allow owners to vote on ratifying that and the other things that needed to happen. So, floods are a genuine emergency, there's no argument about that. And that, I suppose, in a sense, went great in the circumstances. So, but part of that for us was, here's the spending, here's what Mirvac's provided, here's, and really, Commissioner's Office really wanted to know how we were going to let everyone know that this general meeting was coming, to make sure that all of the owners had notice, because back then we weren't, email or sending agendas electronically wasn't statutory. Probably the software was just starting to get there, so we had to put in place a mechanism to make sure that every single owner knew what was going on, and actually went to that general meeting and basically everyone showed up. So was an interesting one. So you can look at a blend of things there. If you need to spend more than you think, but you still want to engage owners, and certainly adjudicators would look more kindly on owners being able to have a say and at least understand what's going on, as opposed to them finding out a decision's been made in their absence by an adjudicator without any reference to them. That is very last resort in my book. It's all about that self-determination, information, and self-governance where it's possible. So again, I suppose part of the art is blending that around. So you can look at those things. Now, probably some of the other things that people might get wrong here. You can't, and this has been consistent with the modules for a long time, if something is a project, if it's a series of proposals that forms a single project, the costs are aggregated for the purposes of spending limits. So if you're doing the front of the building, if you're doing a building refurbish, we're painting the thing, we're doing the foyer, we're doing the driveway, we're doing the gardens out the front. They're not separate things necessarily. That is a building refurbishment program, and we might potentially tie it together. So that's probably a more generous or more open interpretation of it. Another way to do it, maybe we're going to redo the driveway. The bricks cost this, the labour costs this, the boundary walls cost this, the gardens cost this. Separately, they might not go above the major spending limit, but collectively they do. That is a project which requires approval in accordance with whatever the legislation is in terms of major spending limits and all that sort of stuff. So you can't go and approve 5 things at committee level that would otherwise be below the major spending limit. Act requires they be lumped together. So for me, on those ones, it's always better to err on the side of caution, put it together, put it up for approval, and deal with it if owners say no. And again, one of the things with this sort of stuff is if you think it's going to be a hot topic issue in your building, don't make the first time people have heard about it be the general meeting agenda with the quotes. You should be managing them on the way through, telling owners this is what we're doing, allowing people to have a say informally. You don't need to have, be it an owner's information night, be it those little survey monkey things that come out, tell us what colour you want, tell us whether you're happy with this or otherwise, so you can take people's views into account. Because I think one of the things in strata that does tend to annoy people more often than not is not being engaged in the process. Now, I know it's easy to say, well, if they want to be engaged, they can put their hands up and go on committee and whatever it might be. But still, from an adjudication or commission's office perspective, that doesn't necessarily cut it. Just because they haven't shown an indication to be involved to date doesn't mean they don't, or they're not entitled to, know what's going on. So the more information and the more explanation you can provide, the less risk there is to people coming unstuck in terms of technical challenges and that sort of stuff when the voting comes around. Now, Nikki mentioned the webinar we did a couple of months ago, maintenance versus improvements. There is that was an hour on its own. So absolutely, maybe Nikki, when you send this out, you could send a link to that because I've referenced it. There's absolutely caps on committees spending body corporate money on things that are improvements. So the number normally is about $3,000. So even though something is at normal face value might be within a committee spending limit because it's 5 or 6, if it's an improvement to common property, it might need general meeting approval regardless of the spending. So that's not approval because of the spending, it's approval because of the nature of the work that's been undertaken. So I'd highly recommend, if you're interested enough in this and you haven't already seen it, go and watch that webinar because that drills down to a whole lot more detail than what I'm talking about today. And I think if you want the one thing to walk away from to remember is, the spending limits we're talking about today really are keeping common property in good repair and condition the way it should be. So maintaining what's already there. Improving is changing something. Now that can be by demolishing it. It can be by painting it a different colour. It can be by any other different type of change. So probably the takeaway is if it's not like for like, if what the money's being spent on is not the same thing, maintaining the same thing that's already there, you might be off the reservation in terms of spending limits needing approval at general meeting. Just bear that in mind. So that's particularly for strata managers because it's very easy. Here's $5,000 for something. And it's like, but what's $5,000 for what? Are we making a change? Is it like for like? And if it's not, then you need to just double check that you might need general meeting approval for that. Now, the last one, and this has been a continual, I get this a lot, it's in the budget, that means we can spend it. No, it doesn't. You still need to comply with major spending limit rules, with committee authorisations, with quoting requirements, with, if it's an improvement to common property, with general meeting approval. Just because owners have put a line item or approved a line item in a budget is not authorisation for the committee to spend it automatically. This process, so that raises the money that might be spent, and contractually you might be bound by some of it. You know, you might have a strata management contract, you are going to have insurance, you might have a caretaking agreement. You know, you might raise $5,000 potentially for legal fees just in case. But just because it's there and approved and effectively in the bank, I suppose, after 12 months, doesn't mean that you've automatically got the right to go and spend it on that thing. You need to comply with these spending rules I've spoken about beforehand. So they're probably three of the traps that, if you just look at it with your blinkers on about spending, might be okay. But those three things are things that people come across on a lot. And again, the Commissioner's Office is littered with adjudication decisions about those. Now, as I mentioned before, so I suppose this is one, and it applies a lot in relation to strata, applies a lot in relation to a lot of things. Is it easier to seek forgiveness than ask permission? And sometimes the answer is yes. Now, that's not legal advice. That is being commercially pragmatic about whatever it might be. When it comes to strata, and this is a conversation I have with clients a lot. Biggest example, I mean, there's one down the Gold Coast 1,000 years ago. Client wanted to go and they had a commercial unit or a commercial lot. They wanted to go and install this cafe on the beachfront. So lovely little spot, still there today. Client wanted to go and install shade sails and covers and all that sort of stuff outside on the common property. So it was an improvement to common property by a lot owner that they had the right to use. So it was exclusive use area. So client says, what's the rules? I said, well, the rules are you need to go this, you need to do this, you need to get committee approval to do whatever. And he said, what happens if I just build it? So, well, by the time it's done, it'll be too late. And so he just went and built it. So we got a nasty letter from the body corporate, wrote back and said, you know, this is why it's going to be better for the building anyway. And they said, oh, okay. So, you know, those sort of things can happen. Does that make it right? No. And I suppose from a lawyer's perspective, in a sense, it's, you know, our job is not necessarily to tell people what they must do. It's to tell them, here's your choices. So if you choose option A, here's what might happen. If you choose option B, here's what might happen. Now you go ahead and make the decision, and don't come back and blame me if you pick option B and the consequences of that come to fruition, because I'm telling you now, it might not be pretty. Fine. So if clients do that in an informed way, that's great. Which way they want to go depends on how they feel about their relationships with other owners, what the vibe of the building is, you know, commercially, how risk averse they might or might not be, all that sort of stuff. So, you know, it's, I think probably one of the things where lawyers can go wrong is they start imposing their will on clients and say, you should do this, you must do this. And I just personally don't think that's right. But anyway, you know, opinions are wonderful. Everyone's got them. So yeah, that's always a factor. And so applying that to these, another example last week, committee has got something going wrong with the building. They need an expert report. The expert report is definitely above their spending limit. They're talking about going to general meeting to get approval for that. And my conversation with the chair was, you know, and I suppose part of it is what are the consequences? Absolutely, it's beyond what you can do at law. But who is possibly going to criticise you when you've got this bit of evidence of this particular issue with an expert saying we need to get this report? So it's going to be very difficult for an owner to come back at that committee later and say, you should have come back and got our approval before you actually incurred that spending. So, you know, for that body corporate in particular, it's like, well, so there's the forgiveness and permission component is one part of your choices. The other choice is you can make an application for emergency expenditure, or you can call a general meeting and do the dot the I's and cross the T's and get it approved by owners. Up to you. You know, so And because it's a major issue, I'm still waiting for a response on that. So there you go. Live issue. Now, the second point, this is always the question, because this does happen a lot. Absolutely happens a lot. So, part of it is, if a tree falls in the forest and no one hears it, does it make a noise? The answer is no. So, there's 50-odd thousand bodies corporates in Queensland. I can categorically tell you that all of them probably breach what other statutory requirements in some way, shape or form throughout every couple of year period. Almost inevitably that happens. And spending is, spending other people's money, which is what it is always one of these things. So let's say from a committee member perspective, they're protected from acts or decisions made in good faith and without negligence. That's statutory, that's in the Act. The other thing is that every body corporate committee should have insurance as part of their body corporate insurance, what you call D&O if you're in a corporate, but office holder insurance. So they've got insurance if they're sued personally. So they're the two lines of protection in relation to that. And I do get asked regularly, people unhappy with committee decisions or whatever, can we sue the committee personally? The answer usually is no. And why? It's because it's the body corporate that's actually made the decision by the committee. And usually in an adjudication or even legal sense, to sue someone, it's like we don't have that American system where you sue for exemplary damages. You see those claims where someone gets pinned with 200 million because they were really nasty about what they did or the way they went about it was wrong. What our system is designed to do is compensate you for the loss you've suffered in relation to something else going wrong. So in a contractual dispute, that's relatively easy. You agree to buy my house for $1 million, you go unconditional, you don't settle, I then resell it for 950. I come after you for that 50 grand difference. No more, no less, plus additional costs and et cetera, et cetera. But that's the principle of it. I don't get to add $2 million to it because you put me through mental distress in having to do that. And body corporate's the same. So suing a body corporate practically doesn't really make much sense, because to the extent that it's liable, you're going to contribute to a portion of its costs. And suing a committee member personally would need some evidence or some serious diminution in value or some serious financial consequences to justify it. So just because someone might have done the wrong thing, particularly when there's nothing in it for them, they've made nothing out of it, and the money's been spent on the body corporate, it's not ever really going to be worth it, as much as it sounds good in theory. And usually those people that ask about suing have never been involved in a piece of litigation, because leaving aside the cost, it's a horrific experience. You just don't want to go there if you can avoid it. So, and probably the primest of prime examples with this is we had a client, and he was a bit of a point scorer. He's one of those guys, it's all about principle. Principles cost money, and that's fine. So he was in a building, the body corporate committee went and replaced a lift in this building off their own bat. So there's no argument at all. It should have been put up to owners for approval in general meeting, from a both spending limit perspective, from an improvement to common property perspective, from a major spending limit perspective. They didn't get two quotes, they only had the one. They went to the lift contractor and said, bang, do it. And the lift contractor did it. We weren't in the building. It was an investment property for us. So we only realised almost after the work's done that this thing has happened. And so client says to me, what am I going to do? Well, what's the damage? And anyway, long story short, we made an application to the Commission's office, had jurisdiction to do it, for an order that the committee had done the wrong thing and hadn't complied with their statutory obligations. And we got that order. Yes, that is right. So, it's those sort of things. So, and I suppose probably then, so what's the more practical way to deal with these things? If you're worried about committees not spending or spending what they shouldn't be, get involved. Put your hand up. If you put your hand up or you don't want to be involved, then keep a really tight eye on what's going on at body corporate meeting level, at committee meeting level. Go to committee meetings. Read the minutes. Keep an eye on the financials. See what's in the budgets, because the Commissioner's office is there effectively as a bit of a, I wasn't going to talk about interim orders, but here I am talking about interim orders now. they can make orders on an interim basis if a body corporate is breaching its statutory obligations. So if that one, back to the lift one, if we knew that the committee was intending to do that, we may well have been able to stop them before the work started. But the moment the work started, we're gone, because the adjudicators would not have allowed the building to be without a lift for an extended period of time because it needed one. You know what I mean? So you've got to be, if you're really interested enough, you've got to keep an eye on those things. And that's what the Commission's office can actually be there for. But other than that, if committees do go over their spending limits a lot, and that's, part of the response might be it's easier to seek forgiveness than ask permission. I put it this way, I've been asked a lot of times. We've never actually sued a committee member personally yet, because for me, in terms of the advice we're giving to clients, it's never going to be worth it unless there was something catastrophic go wrong. And probably, well, there you go. There's an example I use. I'm sort of answering questions here maybe already, Nikki. Insurance. Insurance in North Queensland has been horrific. We've got clients up there. So again, if you can't get insurance for what you're required to do, you should be off to the Commissioner's office to get an order to effectively waive the lack of compliance for that particular item. And that might be cyclone or whatever it might be. And you've got to go through a process to actually get that waiver. I am absolutely certain that there's buildings in North Queensland that aren't insured for what they should be insured for and haven't got that sanction from the Commissioner, and owners don't know that they aren't insured for the things that the statute requires them to be insured for. Those are examples. I say to those committees, you should not be doing that without getting authorisation from the Commissioner, which normally then requires informing owners, because that would possibly be a ground of punting someone personally if there was a catastrophic cyclone and the building copped millions of dollars worth of damages, and there should have been insurance for that particular issue and there wasn't. No one knew. That might be one of the rare ones that would be justified, but for the other 99.9% of them, there's probably no real point. So anyway, so therein endeth the sermon. We might go back. So there's a little.
No, that's great, Frank. Thank you so much. I really loved the practical examples that you gave on all of those points, and I'm sure that the audience that was in here appreciated that as well. One of the things that people asked about when you were speaking about it was just on the approval for insurance spending. There seemed to be a little bit of confusion on that. Do you mind covering that just really quickly?
Yeah. So they've specifically carved out. So in body corporate budget, there's going to be a line item for insurance, which is going to be raised over a period of time. The legislation specifically allows a committee to put insurance in place above their spending limit requirements if it's required by law. So you might have, the policy might be a $50,000 policy. The legislation allows a committee to put that in place. Full stop. And then it should be ratified at the AGM. So one of the things that bodies corporates that want to have more oversight about those decisions do is put the renewal of insurance to after whenever their AGM date's going to be. So when it gets approved at the general meeting, everyone can see the policy and the amounts and all that sort of stuff, and then voted on, put in place, committee can then press the button afterwards. So in effect, that sort of takes the decision away from the committee and puts it in the hands of the owners. And that there's no hard and fast rule on that, because insurance renewals fall whenever they fall. They might be before, they might be after the AGM, might be halfway through the year. You know what I mean? So it's just a matter of, if that's a concern, it's a matter of looking at the timing and figuring out what you need to do to sort of tie the two together to allow the renewal to follow as closely as possible after the AGM.
Okay, thank you. Hopefully that cleared up a few matters for people. If you've still got questions, just pop that in there. Okay, and we might just have a look at a couple of questions that came in. To change a committee spending limit, is this a vote done by the committee only, or would this be voted on by all lot owners?
All lot owners, ordinary resolution, general meeting.
Right. When a committee has owners who are adamant that they want every cent of spending poured over and voted on by all owners, regardless of the statutory limits, what might be some good techniques for dealing with that?
I suppose, in a sense, it's inviting people inside the tent to have a look at what it is. So body corporate managers run. So my immediate take is, if you're an owner, you're entitled to the information. That's the starting point. So transparency is not something that's discouraged in legislation. It's actually encouraged, and people have the rights to actually go and get information. So from a committee perspective, if you know that certain owners are going to want as much information as possible, then give it to them. What's the downside? You know what I mean? So, because in theory, if you're getting quotes from lawyers, you get the quotes in, you make a decision. That's going to be something that's a part of the body corporate record. So once the decision's made, send it to the owners that are concerned. So here's another one we've just made. That might give the body corporate manager the heebie-jeebies for a little bit, but they've got a contract with the body corporate to provide certain services. If the additional services required are outside the scope, then they charge the body corporate for the provision of them. It's just the nature of the way it is. Chris has probably got some more innovative ones. I mean, we don't do our webinars together as much as like we used to, so I still learn stuff from him when we do, but that would be my immediate lawyer's take. People want information, they're entitled to it. Give it to them.
And one viewer has just asked, if you're not on the committee, what happens if the committee's holding back and they're not prepared to provide that transparency?
Well, then that is the red flag. Because you go and search the body corporate records. You ask the body corporate manager for that information, and they're obliged to give it to you. So it's just there's no reason for a committee not to provide information, unless of course it's privileged, legal advice, or it's an issue in relation to you. What were your deliberations on your bylaw enforcement position with respect to me? Get stuff, mate. That's the exceptions. But if it's just about ordinary spending, then yeah, it should be there.
Okay. And we were also asked, do owners need to take the word from the committee that they couldn't obtain the second quote, or does it need to be somehow documented and presented at a general meeting?
Well, I suppose we're sort of with the major spending limit. So if it's a committee decision that they can make, so it's within their spending limit, but it's above the major spending limit. Again, it's the question. I think if you're in the committee's position, you need to be able to answer the question why. So from an owner's point of view, why didn't you get a second quote? Why couldn't you get a second quote? Are the legitimate questions. So, and to be honest, and then maybe the response is, that example I gave about the lawyer's been doing the job for whatever. We've had the contractor doing this building for the last 3 years and they're familiar with it. That might be sufficient enough. And I suppose then the committee has answered why, and from there, then it's up to the owners, if they really want to dispute the fact they haven't got a second quote, to go and talk to the Commissioner's office or bring an application, and then that why will be tested.
And somebody else asked, why does it have to be 2 quotes? Why not 3 quotes, which is more of a standard? Is that just a practical decision?
It's a practical thing, and I think probably when you're looking at just today, and obviously we do a lot of management rights. I've got a lot of management rights clients who are flat out getting 2 quotes, let alone 3. And you go to smaller communities, particularly, and I've even had this once or twice where people keep coming and quote shop and get a quote, and they're checking you off against using their mates, which is fine, other than the 3rd time when I rang this particular person and said, you know what, unless I actually get some work, I'm not interested in doing it anymore. And that absolutely happens in this contractor land as well, in smaller communities. Mate, I've been out to see your body corporate 4 times. I got nothing. I'm not coming again. So suddenly your available pool of quotes dissipates. And it's hard enough to get them as it is. Okay. So if you want to get 3, you can, but it's certainly not a statutory requirement.
Okay, wonderful. All right, wonderful. Well, I think we've just run out of time, Frank. That takes us right up to the hour. So thank you very much. That was really good. If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.